Sakshi TV's special immigration show with attorney Sheela Murthy from the Murthy Law Firm. Please note that Sakshi TV now has 3 immigration shows every week. On Tuesday at 3 p.m. EST with attorney Sheela Murthy, on Wednesday at 5:30 p.m. EST with attorney Prashanti Reddy in English, and on Friday at 6 p.m. EST with Bhanu Ilindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that Sakshi TV only has no information. Sakshi TV has no any advice provided on this show is only used for legal used for legal advice and is for general informational purposes only. Sakshi TV or its agents will not be held responsible for use of general information. Hello, Ms. Murthy. How are you doing?
I'm doing wonderful. Good afternoon or good evening to you, Thorny, and good evening to all our guests in India, and good afternoon to all our guests in the United States. And of course, on the West Coast, I guess it's also afternoon. Good afternoon to everybody in the US, and good evening to everyone in India. I'm very happy to join you all again today.
Right. So, Ms. Murthy, today's topic is the I485 FAQs. So, I'd like to start off with the general immigration updates. Could you please tell us the immigration updates for this week?
So there's no major earth-shattering latest developments in the past week. Priority dates, of course, have continued to move. You have the I-485 medical. The USCIS issued the clarification that only if you're doing the medical on or after October 1st of 2021, only then you need to use to obtain the new COVID-19 vaccination confirmation for both non-immigrant visas, but particularly for immigrant visas. And, I'm trying to think if there's any other earth-shattering. There's lots of little things going on, but nothing that's earth-shattering that changed dramatically, fundamentally, the US immigration law arena in the past 1 week.
Right.
So we can start either with the FAQs and answer questions or answer live questions from our audience as well, Thorny.
Before we get into the topic, I request the audience to call us on the numbers displayed on the screen for your immigration questions and advice. And before we begin this show with our first question, I'd also like to wish Ms. Sheela Murthy a very happy birthday from our live audience and Sakshi TV.
Oh, thank you so much. I appreciate it. It's a very special, big birthday. And I always say in India, it is celebrated as the grand birthday. So I feel young and happy and joyful because I do what I love with a passion and dedication to help other people, to provide light, enlightenment, and confidence and information and knowledge to people, like with this Sakshi TV show. And giving people hope and encouragement is always very uplifting and exciting for me, just as much as it is for others who can benefit from it. So thank you so much, Thorny, and I want to thank you, Sakshi TV, for these well wishes as well, and to you in particular for remembering it and mentioning it. Thank you.
Right. Ms. Murthy, it's our pleasure. And I'd also like to say that you've, it's a testament to how you've led the Murthy Law Firm, and because the Murthy Law Firm puts on a wealth of free information and online tools for the immigrant community and for the benefit of US immigration community and the lawyers, for the US employers as well. So we'll start with our first caller right away, Mr. Prajay from North Carolina. Thank you for calling, Prajay. You may ask Ms. Murthy your question directly.
Hello, Sakshi TV and Ms. Murthy. Thank you for your service. I have one simple question. For 485 EAD and AP renewal, how early we can file? Because I'm seeing in some sites 120 days and in some sites 180 days. I called to USCIS today and they are not clear on that as well. So could you please tell me how early we can file before the expiry date of the current combo card, which is EAD and AP?
Very good question, Prajay. Thank you for asking that. In fact, the rule always was up to 120 days, because if you filed early and the USCIS got it early, because remember, prior to this excessive delay that has started in the last 1 or 2 years, especially during the prior administration of the prior president, Before that, the EADs and APs used to get renewed within 3 months. So if you applied more than 4 months earlier or more than 120 days earlier, they would think that you are just applying for a replacement of your previous card, which got lost. And so they would only give you the same card all over again and encash your check. So that is why we used to tell people, do not apply more than 120 days in advance. Unfortunately, nowadays, the USCIS is taking 6 months, 8 months plus to approve the EAD and advanced parole, the employment authorization document. So some people are tempted to file earlier, but Project, to be on the safe side, I would say don't file before 120 days. Only apply 120 days before your EAD AP expire. One, because of the rule that they may just give you a replacement. Two, under the new policy that was changed, you know that you can legally keep on working for up to 180 days as long as you filed the EAD and AP combo card extension at least before it expired. So now you will have, even if they take 6 months or 8 months, if you apply 4 months before, plus you can continue to work for 6 more months legally, you should be perfectly fine and not have any gap in your ability to continue to work legally. Because the last thing I want you to do is spend hard-earned money, pay for it, and only get the approval valid till the date of your prior EAD expiration date. So stick with the policy, because USCIS has not changed that, though what they have changed in the past year or so is the ability to renew and keep working based on filing the renewal prior to the prior expiration for up to 180 days. So that's a new factor that can be very helpful, especially with the excessively slow processing that USCIS is doing nowadays. I hope that was helpful for you, Prajay. Thank you.
Right. So, Ms. Murthy, getting back to the topic, what is the I-485 form filed for? I thought I'll start off with a basic question.
Oh, it's a great question. So remember, in whether it's a family-based green card case or an employment-based green card case, that is the 485, or the adjustment of status, is the last stage before getting the green card. So in an employment-based case, the first stage is called the PERM. The PERM is the labor certification, the permanent electronic review management, which is for getting where the U.S. Department of Labor confirms that there is no available U.S. worker to do that particular job for that particular employer in that particular location with that particular skill set. The second main stage for the green card is I-140 petition, where the employer must show that they have the financial ability to pay the employee has all that education and qualifications, and then the I-140 immigrant petition is approved. And the third stage is the adjustment of status. If you're in the US, you can adjust your status from non-immigrant to immigrant, usually from H1 or L1 or sometimes F1 directly to green card or 485. And the reason it's called adjustment is because you're adjusting from non-immigrant to immigrant. And this is the stage where you show that I don't have a major communicable disease. I do not have a major criminal record that would make me inadmissible in the US, or I don't have a major problem that would prevent me from getting my green card. So that is in the employment-based context. In the family-based context, you have the I-130 petition that has to be approved. So for example, if it is an adult child applying for the parents' green card, the US citizen adult child, they file the I-130. When that gets approved, if you're in the US, you file the 485 adjustment of status. If you're abroad, same with employment-based, you can do what's called consular processing, or CP, directly from and with the US Department of State, directly dealing with the US consulates in that particular country. In India, there are only 2 major consular posts that deal with immigrant visas, that is Delhi and Mumbai. And Mumbai deals with the immediate family-based cases, spouse of US citizen, parent of US citizen. Those are only dealt exclusively with the US consulate in Mumbai. So right. I know that's a very broad, big overview. It's the most important stage for the individual, because the other stages, somebody else is involved, whether your family member is sponsoring you or your employer. But this last stage, it is you saying, I am eligible to become a green card holder because I am not financially dependent. I will not become a public charge. I don't have a criminal record. I don't have a public health record that will cause problems for people in the United States. That's
Right.
why it's adjustment.
Right, right. Ms. Murthy, so we have another caller waiting. Mr. Arif from Michigan, thank you for calling. Arif, you may ask Ms. Murthy your question directly.
Hello, Ms. Murthy. How are you doing? First of
I'm
all, I
doing
would like
great.
to
How
say,
are you doing?
your the life, I mean, the attitude and the way you see at the life inspired me a lot. It boosts my mood a lot. So thank you very much for that, and wish you happy birthday. Just came to know. My question is, hello, are you able to hear my voice?
Yes, thank you.
Hello?
Yes, we can hear you.
Okay, so yeah. So my question is, if your renewal, the EAD, if the renewal is pending for EAD, and then okay, you will get the EAD, but just in touch with it, just in case, if EAD got denied, what is the options that we have? Like, you have to leave the country immediately, or can we move back to the H-1B, or how things work if that is the scenario?
Your voice is echoing just a little bit. I'm not sure. So if I understand the question, your question is if the EAD does not come through and get approved within the 180 days that you are allowed to keep on working legally, then what happens? Should you stop working? Well, you shouldn't have to stop working, even if it stops, even if your EAD is expiring. It shouldn't make a difference because as long as you filed it 180 days, as long as you filed it before it expired, you can keep working for the full 180 days. But if the 180 days is getting over and you don't have backup H1 or L1 status that has with the renewal that is filed, because if you had a backup H1B that is expiring, then just by submitting that application, you automatically get 240 days or close to 8 months of valid work authorization on H1B or L1 status, right? So then you keep working on that. But if you don't have H1 or L1, your employer refuses to file it, your EAD application extension that was filed more than 180 days ago, that 180 days has expired and you don't have a new EAD card, then you are required to stop working. You're allowed to stay in the United States, but you're not allowed to stay in the US and keep on working because you no longer have valid work authorization available for you.
Right, right.
I hope that answered your question.
Yeah, I'm sure it did, Ms. Murthy. So we'll move on to our next question, which is, when is the right time to file the I485? Is there a good time perhaps?
Well, the only time that to really file the 485 is when the priority date is current. So if a person's priority date is not current, they obviously cannot file it because the USCIS has to deny the 485 because it is filed prior to the person's priority date becoming current. So in some cases, the person is unable to file the 485 because they may be abroad at that time and they don't want to do consular processing. They want to come back to the US on H1B or L1 status and then file the 485. And as long as the priority date for that person continues to remain current, the person can file anytime between the 1st and the 30th or 31st of that particular month. So it reaches before the new Department of State visa bulletin information is released. Because if the dates go backwards or they retrogress, let's say they retrogress starting from November 1st, and now we are in the middle of October, you have, let's say, till October 31st to file, then you have to file it so it reaches USCIS before October 31st. If the priority dates are still current in November, then obviously you can you'll have the whole month of November from 1st to 30th to file again. But if the dates have got retrogressed or gone backwards, then you cannot file the 485 because the priority dates have to be current in order for the USCIS to accept it and issue the receipt notice.
Right.
So that's the only time to file it.
Right. So this also brings me to the next frequently asked question, which is, how long will a medical examination result be valid, Ms. Murthy?
So if the person had applied for the I-485 and the medical at the same time, then the USCIS gives it a much longer time for it to remain valid. I know they've gone between 1 year to 2 years and even up to 4 years in some cases, But if you file it afterwards, not along with when you file your I-485, then it's the maximum time it's valid is for 1 year, unless USCIS makes an exception, which they have done from time to time, saying that we will continue to honor the medical for the particular group of people for up to an additional 6 months or 1 more year in some cases. So the USCIS has the flexibility to increase that time when the medicals are valid. But in general, if you file it after you file the 485, which most people prefer because of the priority dates going retrogressing, people don't like filing it because they are afraid that they will then have to again go through the medicals. So when the priority date finally becomes current, then they go and quickly run and get the medicals done. But when they do it, then it remains valid for at least 1 year unless USCIS extends it for additional time.
Right, right. So then what does one person typically do after filing the I-485?
So, well, you wait for most people apply for the EAD card and the employment authorization document, or EAD, and the advance parole in order to be able to travel and return back to the United States. So people just file it. They're allowed to stay because you're considered in a pending 485 status, pending adjustment of status. And till when you get the EAD card, which offers you unrestricted employment authorization. It's not like an H-1B where you can only work with that particular employer for whom you have the H-1 approval. EAD allows you to work for any employer, anywhere, as long, and if it's an employment-based case, then ultimately when the 485 is approved, before it can be approved, you have to show that you're doing either the same job or very similar job, file the supplement J with the new employer, and then you can continue working in that job.
Right. So this brings me to my next question. Can a person probably file their EAD or advance parole along with their I-485, as in like simultaneously?
That is correct. Most people do prefer to file it simultaneously because then you have to wait 6, 8 months, 10 months. So you obviously want to file it the earliest opportunity that you can. And the earliest you can file it is with the I-485 application for adjustment of status.
Right. So does that mean this also has a very thorough or probably a detailed documentation required to file the I-485?
The I-485 is an extensive document, has extensive documentary requirements, Tharani. So from showing the employment of, your eligibility, your birth documents, marriage documents, financial documents. I know they've removed a lot of the public charge requirements with very burdensome and onerous paperwork, but still there is lots of paperwork with showing the, birth certificates for each of your children if they're applying with you. Plus, if you're doing the EAD and AP, then proof of that application and eligibility and what is your status. Also, if you've been out of status in the employment-based context for more than 180 days, then 245K, Section 245K of the Immigration and Nationality Act gives you sort of a quasi-grace period for up to 180 days where there's some gray area or mismatch in your employment authorization. But if you have a gap of more than 180 days, then your 485 cannot be approved within the United States. And in the family-based case, there is not even 1 day grace period unless it's immediate relatives. What is an immediate relative? An immediate relative is actually a legally defined term. You may think, oh, my adult child is my immediate relative. Obviously, it's my child. No. U.S. immigration law does not consider adult married child of a U.S. citizen to be an immediate relative under U.S. immigration law, so that if they were out of status and living in the U.S., even for a week or a month or whatever, that 485 cannot get approved. So what do we do in those cases? In many of those cases, we send the person to India to do the consular processing that I just explained, so that the person and the family members can enter on as immigrants or green card holders on the immigrant visa. Now, of course, if the person was already out of status for more than 180 days, or in worse, for more than 1 year, then there is a 3-year bar or a 10-year bar for that person to re-enter the United States as a permanent resident, which is obviously very, very disconcerting. So it's very important not to fall out of status or to remain unlawfully present in the US because it will prevent your 485 from getting approved, particularly in the family-based context, unless you're the exception, the immediate relative, which is spouse of a US citizen or a minor child of a US citizen or the parent of a adult US citizen sponsoring you. Other than those three categories, you are not going to be able to adjust your status in the US at all if you were out of status even for a few days.
Right. Right. That was very detailed, Ms. Murthy. We're grateful. We have a caller on hold, Mr. Chandrasekhar from New Jersey. Thank you for calling, Mr. Chandrasekhar. You may ask Ms. Murthy your question directly.
Sure, thank you. Good evening, Attorney Sheela Murthy.
Hi, Chandrasekhar. Good afternoon to you too.
My question is, I have downgraded my 485 petition. From EB2 to EB3 scenario is mine. I downgraded and filed the 485 petition. I-140 is approved and 485 is pending now. So I'm waiting for my EAD. Is there any way, to process EAD in premium processing?
So the USCIS had passed the law last October of 2020, to allow for premium processing, including 485 EADs. The problem is USCIS has not issued the final forms and regulation and process. They were said they would do it by September of 2021. Well, it's already October, middle of October, and we don't have the final forms for it. So premium processing is supposed to be allowed on most EADs, including 485 based EADs, Chandrasekhar. But the problem is they haven't, as I said, released it. The other issue is there is something called expedite, but you have to show the extreme harm to the employer, to the economy, to you, along with other factors, and show that there was no delay on your part to request the expedite and for USCIS to approve it. So on the one hand, there is a law allowing premium, but unfortunately they have not finalized it and issued clarifying regulations or the form to help you. So if your EAD or your H-1B is expiring, please talk to your employer to extend the H-1B petition, because that will allow you, just by filing the extension, and don't pay premium processing for it, because as long as it is pending, you can legally keep on working for up to 240 days or 8 months based on filing an H-1B extension before the prior H-1B expired. Good luck, Chandrasekhar.
Right. Moving on to our next question, Ms. Murthy, could you please explain to us the processing procedure of an I-485?
So the processing procedure is your priority dates current. Hopefully you can either do your I-140 concurrently, because the perm was filed and approved in the employment-based context, or if it's an immediate relative in the family-based context, you can file the I-130 with the 485 concurrently, or after the perm is approved and the priority date is current, you can file the I-140 and the 485 concurrently with the EAD and AP. You just go through the checklist, you go through the forms, you attach all the documents, you put the filing fees and the checks. If there's a lawyer involved, you include the G28. You have to be very accurate and detailed oriented, point by point by point. And if everything looks great, the dates remain current, then bingo, your 485 could actually get approved. On the other hand, we seek fairly often where sometimes the USCIS will issue a request for evidence, or RFE. And depending on what the issue is, sometimes it's about your status. Did you maintain H1 status, or did you maintain F1 status before H1B, etc. Then the burden is on you as the 485 applicant to show eligibility for the 485 approval. The burden of proof always under US immigration law lies with the person seeking an immigration benefit to show that you are eligible to get that approval from the USCIS. And if there is a gray area or you're not eligible, then the USCIS does not have to go out of their way to help you to get your 485 approval.
Right.
Thank you.
Right. So, Ms. Murthy, is an interview required for the I485 adjustment of status?
Yeah. So by law, the interview is not required for every case. In fact, the policy was supposed to be pre-Trump administration where there was no interview ever required for an employment-based case. Years ago, they changed that policy because they realized that there was no need to waste precious resources with USCIS examiners scheduling very standard perfunctory employment-based interviews. But during the prior Trump administration, of course, they tried to put as many obstacles as they possibly could. And so they ended up putting obstacles, including requesting or requiring mandatory employment-based interviews. Now the policy is not mandatory, but what they are now doing because of, and it even started in the Trump administration itself, even though they put the policy where because they were so short-staffed and spread thin, that they only have interviews when there's questions or for a random basis. In most other cases, the interviews are waived if all the paperwork looks fine, there's no problem, and the USCIS can approve the I-485 for the principal and all dependents who are below the age of 25, either on the day the 485 is approved or for children if they are protected under CISPA, the Child Status Protection Act. Then those children who are legally considered below the age of 21 can get their 485s approved with the principal applicant and the spouse.
Right. Right. This also brings me to the last question. How much cost is involved for the filing of an I-485, Ms. Murthy?
So the USCIS filing fees are mentioned on the form. I don't even, really focus. It's over $1,000. Plus you have the EAD and AP. At one time, they thought they would consolidate everything, reduce the fees, make it more streamlined. But as I often say, with the USCIS, the fees keep on increasing, the quality of service keeps on reducing. And if you or I were in business, running a business like that, we would be shut down. And not only would we be shut down, we may be blamed for theft and fraud because they take the fees saying that we will process when they introduce the premium processing for H-1B. I remember all H-1s used to take 2 to 3 months to get processed prior to the premium processing fees. And USCIS promised that it will never become more than that by taking premium processing, that they will only do premium processing cases within 15 days. Guess what? The normal cases kept on increasing, and now it takes 6 months to a year for a regular process. So it is almost like we are rewarding bad behavior. We are rewarding incompetence because from 2 to 3 months for processing an H-1B or 2 to 3 months for processing an EAD, now we are rewarding them for them to take 8-10 months. So the only way we can get a faster approval is by paying them the legal fees of foreign expedite, which is another $2,500 or $1,500, which in my mind is outrageous and unacceptable for a service that I think should be included as part of professional courtesy. Congress itself has said over and over again that almost every process should be resolved within 6 months.
Right.
But that has not been happening with USCIS.
Right. Thank you for that detailed explanation on every question that we've asked on the show, Ms. Murthy. With that, we come to the end of the show, and I'd like to say by concluding that it was a privilege hosting you again, and thank you for being on the show, Ms. Murthy.
It's a privilege and an honor, and you take care and stay safe. And as we grow older, the only things that matter in life are helping people, changing lives. In India, we talk of the principle of dharma and karma, and that's all that matters as we grow older and wiser. So thank you for allowing me to help other people and continue to educate and enlighten them and empower them with knowledge. You take care and have a wonderful day. And thank you to you, Thorni, and to Sakshi TV.
To a healthy and happy birthday for Ms. Murthy. You're watching Sakshi TV with me, Thorni Makana. Thank you.